Good afternoon, everyone. Welcome to Weber Gallagher's University Educational Programs. This is our Workers' Compensation webinar series. I'm Alan Arsenis, and this is John Kuttner from our North Jersey office. We're both here in Mount Laurel to give this presentation today. Each month we present a current topic in workers' compensation legal issues. We present both case updates and ways to manage risk in your businesses. If you would like to view this webinar again, share it with others, or see it other WG University presentations, please visit the Weber Gallagher website at www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact us at questions@wglaw.com. Today's presentation is entitled Cutting Off Temp, Curative versus Palliative Treatment, MMI, and Voluntary Tenders. Next month, our topic will be considering Medicare's interests, conditional payments, and set-asides. Let's get started. Temporary disability benefits, as defined by Sections 12 and 14 of the Workers' Compensation Act, provides for wage loss benefits when people are injured as a result of work injuries. Essentially, to be entitled to workers' compensation, temporary disability benefits, you have to be out of work for a minimum of 7 days. And on the 8th day, your entitlement kicks in and starts from day one and ongoing. You must be under active medical treatment, because it is typically a doctor who says that you cannot work. And to calculate wages, we typically use the 26-week wage history, which is provided by the employers. We do an average of the 26 weeks, obviously divide by 26, and that's how you get your average weekly wage. Typically, you are supposed to take into consideration overtime, gratuities, and even lodging if that is part of the petitioner's wages. When terminating temp benefits, there are multiple ways to do so. The most obvious way is when the petitioner is discharged from active medical treatment, or if they have been discharged to return to work with light duty restrictions, petitioner is still treating, and the employer can provide the job. It is always the employer's obligation to provide the job with light duty restrictions. Another basis is if, obviously they are discharged from treatment with permanent restrictions, temp does not continue. There is a current case that came out about a little more than a year ago, that talks about when a person goes back to work with light duty restriction, but is earning a wage much lower than normal and even lower than their temp rate. And that's the case of Soto versus Hers that was decided by Judge Cox. In that case, the petitioner injured his left knee on January 29th, 2001, and on January 2012 was released to light duty 4 hours a day. The average weekly wage for this individual was $976.15, while their light duty net pay was only $329.43. The issue in this case was the petitioner entitled to the difference between what his net earnings were on light duty compared to his temp rate? In that case, Judge Cox ruled that he was entitled to partial temp. And the reasoning behind that was that Section 12 provides benefits to the petitioner that are supposed to allow him to maintain his living expenses while treating and working light duty, obviously, or not working at all. So in that case, the judge felt that the respondent was required to remit the difference between the temp rate and what the petitioner was earning on a net basis. It's important to note that the respondent in that case did not take an appeal, so there was no appellate review to determine whether or not that was accurate rendition of the law. It is an unreported case, so not everybody knows about it, but it is becoming more and more prevalent in the division. It's important to note, though, in this case, the petitioner was under active medical treatment, he was not discharged, and he was earning significantly less on light duty. Another important case to keep into consideration is the case of Catalini versus AIG. In this case, the petitioner filed a reopener to a prior award of 33 1/3 of partial total. The respondent had the petitioner examined for a need for treatment exam, and the doctor recommended a total knee replacement. The petitioner was receiving at the time unemployment benefits when surgery was recommended. And the issue in that case was, is the petitioner entitled to temporary disability benefits when they're not actually working? And the court ruled that he was entitled to the wage loss benefits, stating that temp would be owed from the date of surgery until full duty release or MMI. And the reasoning behind that ruling was that unemployment is a substitute for wages and is considered income by the federal government. A person must be able to indicate that they are ready, willing, and able to work to be entitled to unemployment benefits. In this case, the petitioner was not able to work after the surgery and therefore could not certify that they were ready, willing, and able to work, at least not until they were released at MMI or full duty. Therefore, temp was owed as wage replacement. Another important case is the Dylan Hewlett case versus Farmright Inc. In this case, the petitioner suffered a compensable accident with injuries on March 30th, 2012. He was receiving authorized medical treatment and wage loss benefits until he reached MMI on October 11th, 2012. But it is important to note that he was terminated from his employment the day after the accident due to the motor vehicle accident, which was his fifth or sixth motor vehicle accident, and thus he was terminated for good cause. At the time, the petitioner showed no attempt to obtain any employment since the date of his termination from this employment. In December of 2014, the petitioner filed a motion for additional treatment, primarily seeking psychiatric and pain management treatment. The pain management doctor put the petitioner out of work on February 3rd, 2015. The comp judge found that petitioner was not entitled to receive temporary disability benefits. He noted that the basis for the termination was irrelevant, and he reiterated that temporary disability benefits is designated to substitute for current wages. In other words, it's supposed to be a wage loss benefit. In that case, the petitioner argued that the case of Aaron Dorsey versus First Atlantic Federal Credit Union should be controlling, as it is on point. However, the judge distinguished that from the Hewlett case, noting that in Dorsey, the claim for temp benefits happened before the petitioner was terminated and after petitioner was terminated. Petitioner never reached MMI or returned to work, where in Hewlett, the worker had already received temporary disability benefits, found to be at MMI, while in Dorsey, benefits were denied from the outset. In the Hewlett case, the judge found that in order for the petitioner to prevail in his application for temporary disability benefits, he must prove an actual loss of income, which is essentially the theory behind the Act. Temp disability benefits are wage replacement, and if there is no wages, there's nothing to replace. The nice thing about this case, it reaffirms the Cunningham rationale that for a petitioner to be entitled to resumption of wage loss benefits after being separated from employment, he or she must prove they're actually seeking employment when the disability reoccurred. Otherwise, there are no wages to replace. Now, John Kuttner is going to start with medical benefits.
Good afternoon, everybody. Thanks, Alan. I'm going to talk about medical benefits, more specifically focus on curative versus palliative treatment. Starting out with the statute, NJSA 34:15-15, it requires the employer to furnish all such medical, surgical, or other treatment as it shall be necessary to cure and relieve the effects of the work injury and to restore the function of the injured member or organ where such restoration is possible. Notable there are the words cure and relieve the effects. And medical treatment or payment of such isn't construed as an admission of liability. I myself have had cases, I'm sure Alan has, where adjusters pick it up, it's reported, we provide treatment in good faith, and thereafter we have some investigation and find out that maybe the petitioner is not on the up and up, at which point we can cut off treatment and deny the case. I want to just quickly, we're talking about curative versus palliative. Curative, everybody's probably familiar with, to cure the injury, to try and restore the petitioner back to 100% or as close to as possible. I'm going off the slides a little bit here, but try and bear with me. I think it's good for a little bit of background. Try and get the petitioner back to as close to 100% as possible. Obviously, that rarely happens if it's a compensable injury. And the difference between curative and palliative is palliate. I have the definition from Webster's, is to make the effects less painful, harmful, or harsh. Palliative care is typically a kind of care for people who have serious chronic illnesses. It is different from the care to cure your illness, as I've already mentioned, and palliative care focuses on improving the quality of a petitioner's life. Pain management is a type of treatment or medical benefit that we oftentimes provide. And typically it becomes a significant factor in three situations. When complaints persist for a non-viable surgical candidate, after a poor result from surgery, a worker with chronic pain situations, and many times a recommendation for pain management is requested by an authorized treating doctor or physician when that physician determines that the petitioner is at MMI from a surgical standpoint, and therefore all options in terms of curative treatment has basically been exhausted, and the option thereafter is palliative care or pain management, which is to try and reduce the effects of that injury. Petitioner can undergo several types of treatment in an effort to control and maintain the worker's level of pain. At this point, it's typically the medication that includes opiate pain medications or narcotics that have been ineffective. Additional types of pain management are nerve blocks, selective nerve blocks, and there are 3 types of epidural injections that can be provided. As noted in the statute, we are, or the carrier is responsible for providing all reasonable necessary medical treatment that will cure or relieve. Those are the 2 key words of the effects of the injury. Pain management falls into the category of relieving, obviously, the injured worker of the symptoms associated with the injury. So what about palliative care? The issue arises, and the leading case on that is a case called Hanrahan versus Township of Sparta. This case is a 1992 case. It involved a police officer who was involved in a motor vehicle accident. Treatment was initially provided, but due to ongoing kitchen sink allegations, meaning all different types of complaints to different body parts that the petitioner had, the treating physician recommended an additional 6 months of treatment, and anything afterwards, he stated, would be palliative in nature. So after 6 months, the respondent cut off treatment. Counsel for petitioner filed a motion for medical and temporary benefits. The court reviewed it, and the holding was, even in non-total disability cases, the statute 34:15-15 provides that for continued treatment, whether or not labeled palliative, as long as there is a showing by competent medical testimony that the treatment is reasonable and necessary to cure and relieve the effects of the injury. So they held for the petitioner here, and I believe the treatment that was being recommended was a TENS unit and some physical therapy. Obviously, those are situations wherein, we oftentimes provide physical therapy. It not only alleviates the symptoms of pain that the petitioner has from many types of injuries, but it can also improve their condition. the court did add a proviso, which stated, obviously there is a point beyond which reason dictates that pain or disability experienced by the worker is insufficient to warrant expense of active treatment. And what this seems to be implying is that there's a limit a petitioner can reach, that the ongoing palliative pain management can be cut off and no longer reasonably necessary. In the Hanrahan case, the court indicated that the petitioner had not reached that level, but they're giving us what appears to be an out at some point with that statement. So where does this leave the carrier regarding providing pain management? It's required by statute, and it must be reasonable and necessary to cure or relieve the worker. It should be closely monitored for effectiveness, and if at some point it can be considered no longer reasonable. So it's all, it's practically speaking, you got to keep an eye on it. Pain management, obviously, in what we do is something that it's a last resort. I try to avoid sending petitioners to pain management doctors at all costs because, as you all probably know, once they get linked up with a pain management doctor, you're going to probably be providing that treatment for quite a long time. There are a few pain management doctors in North Jersey where I practice that I could recommend, one being Dr. Brady and Dr. Giancoma. They are both fairly conservative as far as I know, and they don't opt for the pain medication very quickly. They will try other routes such as injections to try and relieve the petitioner's complaints. So moving on, I am now going to talk about maximum medical improvement, or as we refer to it, MMI, and some of the issues that arise with regard to that. As Alan stated earlier, discussing temp, a worker is entitled to temporary benefits, or 70% of the average weekly wage, which is 26 weeks prior to the injury, averaged out, or as close to that as we can get, until they've been determined to be MMI, or maximum medical improvement, at which point both the petitioner can return to work. Maximum medical improvement means there's no additional treatment that will lead to medical improvement. If a worker is MMI but is still unable to work, they can potentially receive total disability benefits, which means that compensation for disability, total and character, shall be paid for 450 weeks. So if someone has received benefits, for 400 weeks or 450 weeks, that's total. And at 400 weeks, you can be pretty certain that the petitioner is likely not going to be returning to the workforce, at which point you can convert them over to perm total. If the petitioner cannot return to the employment at the expiration of 450 weeks, benefits shall continue to subject to the periodic reconsiderations and extensions. So after 450 weeks, the statute provides that the petitioner's benefits will cease, but practically speaking, that doesn't typically happen, because if they've been out for that long, it's highly unlikely they're going to be returning to them. So that's total with MMI. Common issues that come up or are related to the findings of MMI or not finding petitioner MMI, and what can you do? A typical situation that I encounter is an adjuster giving me a call and telling me that an authorized treating doctor is continuously treating a petitioner months, years on end, and has not found them to be MMI, and what can we do about it? Well, my suggestion is typically arrange for a second opinion with another reputable treating doctor. Oftentimes, I will find out, or sometimes adjusters will send petitioners off for an IME after we've been providing authorized treatment with a authorized treating doctor who's not giving us an MMI. And every time that happens, more often than not, that is a waste of your money and time, because a judge is going to put very little weight into an IME report, especially when you have an authorized treating doctor who has a history and a relationship with the patient. And then we have a report, or a 3-page report from a doctor who has seen the petitioner once, stating that he requires no additional treatment. So again, the best course of action is to likely send him off for a second opinion with another reputable treating doctor who we can say is going to take over treatment if he feels as though additional treatment is necessary. Another option, we're going to get into surveillance as an option, but another option is, and this may be the best option when you're having a problem with an authorized treating doctor who maybe you're questioning his opinion, is before sending him for a second opinion with another reputable doctor, is conferencing it with a judge. And I'm not sure about South Jersey, but in North Jersey, most of the judges have their opinions on all the doctors. And if you get the judge's opinion and recommendation for a doctor, and you send that petitioner off to that doctor, you're more than likely going to have the judge behind you to get that opinion. And that really cuts out and saves a lot of time and potential litigation costs from having to go forward with a motion for medical and temporary benefit. And as I said, so another option is putting surveillance on a petitioner who may appear to be a malingerer or who is just not getting better, continues to tell the doctor that the pain is still bothering him and the doctor will not find MMI. And I've had a couple cases myself where surveillance has been put on a petitioner who, say, has been treating, for an extended period of time beyond what that particular injury would warrant or seems reasonable. And on a couple of occasions, we've gotten the petitioner doing activities outside of work while they're saying they cannot work that don't line up with what the doctor or what he is telling the doctor or she is telling the doctor. And when you get those contradictions between the surveillance and the doctor's records, you provide that information to the doctor and ask for them to comment on it. And typically that will hopefully change the doctor's opinion, at which point you can get an MMI finding. And I am going to kick it back over to Alan, who's going to talk about voluntary tender.
Before going into voluntary tenders, I do want to follow up with one point that John made, and that is conferencing with the judge to get their opinion on a doctor they respect. In Monmouth County and Ocean County, the two jurisdictions I go to primarily, every time I'm faced with a motion for medical and temporary benefits, I never schedule a doctor until I conference it with a judge, unless I know that particular judge has a specific favorite expert they will use. For instance, in front of Judge Leslie Barrett in Freehold, when it comes to a shoulder case, I know if I use Dr. Abrams from Princeton Orthopedics and he comes back with a defense opinion, I have a clear-cut winner. So it's very important to use doctors that the court respects, more so than who we may respect or who our adversaries respect, as long as we trust that they will give us a fair opinion. Moving on to voluntary tenders. Section 64 of the Act does allow for an employer or carrier to make a voluntary payment of permanency once treatment has completed. Typically within 26 weeks of having either reached MMI or discharged to return to work, whichever is later, is the best time period to make those payments, because making a payment within that time frame creates a situation where the voluntary tender is considered bona fide. A bona fide tender is important because when it's bona fide, you don't pay an attorney's fee against that amount paid. Tender payments of all accrued permanency benefits from the last date of TTD. It's also important to note that a VT can be withdrawn or modified prior to full payment. Not many people know that. If you start a VT and for some reason you decide you want to pay less or pay more, you can change that along the way. And again, the most important thing is to make sure if you're going to make a voluntary tender, do it during a period of time where it's bona fide so you can avoid paying the counsel fee on that portion. The respondent's portion will be avoided. Obviously, the petitioner will still have to pay his portion against the VT. The advantages of making VTs pre-litigation It does provide an ongoing stream of income for the petitioner, especially if they have not returned to work. It reduces the carrier's share of the fee, which is approximately 12% of the VT that is bona fide. The other 8% is payable by the petitioner. And in some instances, before the petitioner has retained an attorney, they may be satisfied with the VT pay, not knowing that they're entitled to more. And that's the end of the case. They never file for permanency. Post-litigation, it can help when you're potentially facing a motion of intent. You can make a VT while you're either getting an independent exam. Typically, counsel will forego filing the motion, especially if they're reasonable counsel. You can also end TDB benefits in the high exposure cases where the claimant is discharged, they haven't returned to work. If you pay them a voluntary tender, it helps give them some support while we're either waiting to move to permanency or waiting to resolve an issue as to further treatment. Obviously, the disadvantages of VT, if it's pre-litigation, it may cause litigation. Most instances, a claimant gets a check. They've never had a workers' comp claim before. The first instinct is to think, why am I getting this check? Perhaps I'm entitled to more. And they run to an attorney who tells them, you're entitled to a lot more. If the VT is too high, which was happening several years ago by an insurance carrier who, to send a message to the court, they were paying voluntary tenders for the full value of the case. Unfortunately, it backfired on them because judges who see a voluntary tender that they consider excessive or full value typically will take the position that you're doing this to cheat the counsel or petitioner's attorney out of a fee. And a case that was worth 15 or 20 has now gone up to 30 or 33 1/3. So you have to be very careful when you're making a VT so that it's not excessive and the impression is not given that you're trying to cheat counsel out of a fee. Otherwise, you're going to find yourself paying a much higher percentage of disability on that case. Case to note on point was Merichetti versus Palermo Supply Company. In this case, the adjuster made a voluntary tender of permanency pursuant to the statute before the employer had petitioner evaluated by an expert to determine a perm rating. The issue in that case was whether such an offer, which turns out to be higher than the percentage of disability assessed by the respondent's expert, is still in good faith and reduces the respondent's liability for a counsel fee. The holding was yes. The court ruled that respondent is entitled to a full offset of counsel fees and full credit for the VT. And that is essentially because they did it in good faith. There was no perception that they were trying to cheat counsel out of a fee because it wasn't excessive. It was a little more than the rating they got, but it wasn't excessive. It's important to note that there was a Senate bill, 347, that was introduced to eliminate credit for counsel fees. This passed in the Senate. Essentially, the bill was structured in a way so that any VTs paid, the respondent would not get a credit whatsoever. On June 30th of 2014, the Senate passed the bill, eliminating the employer's voluntary tender credit on the employee counsel fee unless the VT is made before the employer retained counsel. Right now, that same bill is pending before the Senate and the State Assembly and has not been considered yet.
Well, thanks everyone for attending. We'd like to thank you for attending the webinar, MMI Cutting Off Temp, Curative versus Palliative Treatment. Our next program will be on September 27th from our Philadelphia office, entitled Considering Medicare's Interests, Conditional Payments, and Set-Asides. Pennsylvania attorneys will review how to consider Medicare's interests for past treatment, conditional payments, and future treatment, or set-asides. On September 13th, we are having a webinar entitled How to Prepare for the New Overtime Rules. This program will discuss the new overtime rules that go into effect on December 1st, 2016, These changes will affect millions of employers by vastly increasing the number of employees eligible for overtime under the Fair Labor Standards Act. It is essential to understand that these rules and take steps to protect your organization. You can learn more about this program and all other Weber Gallagher events at www.wglaw.com/WG-University. Thanks very much.
Thank you.